of the 2025 council, new council with the town of Thorsby. My name is Donna Tona. I'm the Chief Executive Officer. My job tonight is to open the meeting, to have the new council sworn in, and then I turn the gavel over to our new mayor. We have two members of council here tonight, Councillor Jonathan Miller and Councillor Tracy Musson, who's our incumbent. And although Tracy comes back to council, we are saying goodbye to Councillor Miller tonight on a great 4 years. Councillor Rash is otherwise occupied at a meeting tonight, and Councillor Gilbert is occupied at a meeting tonight. The mayor is also an incumbent, but he's getting ready to come in and take his rightful place and at the head of this dais. So welcome everyone. We have a member of our fire services, Lieutenant Sean Cook, is going to be escorting in all the candidates to come in and take their oath of confidentiality. We have our legal team here from Reynolds Smith, Andrew Skeeth, who will be swearing in the councillors and providing them with their oath and having all the signatures. And then we move to a inaugural orientation meeting of council, and then we move to a regular meeting of council. This meeting is called to order at 7:01. May I have candidate for mayor elected, Daryl Hostin, please. Please continue, Andrew.
Please recite the oath.
I do solemnly swear and affirm that I will diligently, faithfully, and to the best of my ability fulfill the duties of the office of the chief elected official, mayor, which I have been elected. Help me God.
Perfect. You can just go ahead and sign. Congratulations.
Thank you very much.
Sir, you stand to my left, please.
I will certainly do that.
Thank you, sir. May we have candidate inaugural elected for council, Ms. Tracy Musson, please. Thank you.
Please recite the oath.
I, Tracy Musson, do solemnly swear that I will diligently, faithfully, and to the best of my ability fulfill the duties of office of councillor to which I have been elected, so help me God.
Congratulations.
Thank you.
Congratulations.
I don't know whose hand I'm shaking.
You had your glasses on.
I know. It's like reading. Oh my gosh.
May I present candidate for councillor, elected by acclamation, Audrey Watson.
Please recite the oath.
I, Audrey Watson, do solemnly swear or solemnly affirm that I will diligently, faithfully, and to the best of my ability fulfill the duties of the office of the councillor to which I have been elected. So help me God.
Perfect. Congratulations.
Thank you.
May I have Carrie Levins enter the room, elected candidate for councillor. Acclaimed, I'm sorry.
I, Gary Levins, do solemnly swear or solemnly affirm that I will diligently, faithfully, and to the best of my ability fulfill the duties of the office of councillor to which I have been elected, so help me God.
May I have Kevin Reynolds, acclaimed for councillor position?
Please recite the oath.
I, Kevin Reynolds, do solemnly swear or solemnly affirm that I will I will do diligence. Sorry, guys, I have dyslexia. I will diligently fulfill and to the best of my ability, fulfill the duties of office of councillor to which I have been elected to, so help me God.
Good. So, great.
Thank you. Ladies and gentlemen, your 2025 for 4 years Thorsby Council. Typically at this time we ask for a picture of council. I'm going to move this chair and one with you as well, Sean, with council. And after the pictures, I will relinquish my duties back to his worship.
And it's right in the middle of the Thorsby logo.
Mind this one?
Are we in group first? Okay. Sorry.
Do you want the mayor in the middle, Jesse?
Yeah, that's very cool. That's
Deputy Mayor there. It's fine. You made it easy.
perfect. Everybody ready? Looks good. You want solos?
Sure.
Coverage order?
Thank you.
Sorry, I'll turn down.
Smile there.
You're smiling. You're good.
You never know how good you look until you get your picture taken.
You're good though. You look good. I got it.
Did you go close, Jess, for the?
Thank you.
It's a happy day on
Smile.
There we go. That was good. Okay. Perfect smile. Thank you. Perfect.
Congratulations.
Oh, I see a remnant of a smile here. It's happening. It's happening.
The only one you
Okay,
get.
ready?
Oh, that's the bill that's coming.
Don't come close, Kevin, a little more.
Perfect.
Your councilors, you may take your seats at your appointed signs and chairs.
Thank you all. Thank you, Donna.
I think we switched you.
As CIO, I hereby relinquish my part of this meeting, and I present to you Mayor Austin and his new council. Thank you.
Yeah, okay, they switched. Because I knew where I was supposed to be.
Very simple.
Everybody a minute to get their seats and then we'll proceed.
Big ahead.
Yes, I'm gonna sit over here. Sit over there, player, and keep her still.
You're welcome.
Too much trouble there? That's what I told him. Yeah, the cameras don't work unless he smiles.
Okay, so,
The smiler.
well, we've done 4.1, the official running of science of office. So next on the agenda will be 5.1. Legal team council orientation training, we're all reminder, and we have here from Reynolds, Mirth and Richard and Farmer LLP, Andrew Space.
Thank you very much. Where do you want me, Donna?
Wherever you like.
Where I can just
Wherever,
run
yes,
there?
wherever you
Okay.
like.
Maybe I'll come stand up here.
Sure.
All
Lots of
right.
We'll have your power coming up right away.
Okay, perfect. While we're doing that, I'm just gonna pop open my computer. Is there a clicker anywhere?
Oh, just let me know when it's done.
Okay,
Sorry, we're not that
perfect.
rich.
Well,
We're working
click
on it.
away for the first three slides. Let's get past that. Okay, yeah, maybe let's go back to the outline. Okay, well, everyone, my name is Andrew Skeet. I'm a partner with Reynolds Mirth. Congratulations again to the new council and returning councilors. So this is kind of an interesting experience. Most of our council orientations that we do are either before council meetings or in a closed session. There's nothing wrong with doing it in an open session. We're just, all you people in the gallery are going to have an interesting time listening to me talk about the MGA for an hour and a half. So hopefully it's educational for all of you. So effectively, what we're doing here is the MGA mandates counselor orientation. And I understand that all of you already took a form of that yesterday.
That's correct. We did 101, yes.
Perfect. Okay. So I'm not going to cover all of that again. That would be a waste of everybody's time. So instead, I'm going to focus on the real legalistic things that you all need to know. And this list, you know, it goes through municipal organization and function. We're not really going to talk about that. I'm really going to talk about 5 things. I'm going to talk about, as counselors, legally, what can you do? What is the source of your authority and how can you exercise that authority? What can't you do? And really what you can't do is anything your CAO can do. And then I'm going to talk about a section in the middle about basically liability. And the liability portion will have 2 aspects. The first will be focused on pecuniary interests and conflicts of interest. And the second portion will be focused on more just common law liability. So unauthorized expenditures and defamation. And finally, I'm going to talk very briefly about some privacy legislation, really just talk about in camera, like when do you go in camera, what does that mean? And then if we have time, and we'll see, we might talk a little bit about Part 17, planning and development. I'm not sure if I will cover that because that isn't the most important aspect of this. So yeah, so that's the outline. Any questions for me before we get into it? No questions. Perfect. All right. You can click away. I'll let you know when to stop. Next one, please. Okay, that's good. That's good. Perfect. Okay. So, as council, your legal authority rests in this section 201 of the Municipal Government Act. Basically, what it says is that council can act by 2 things, 2 forms of action. You can pass a resolution or a motion, and you can pass a bylaw. If you do anything else in any other form or action, say walk into your CAO's office and say, hey, I think you should put up Christmas lights in this specific, shape or form, that has no legal authority. It's a gentle suggestion at best, and your CAO is free to disregard. However, if you pass a motion at a council meeting, as long as it's within the general jurisdiction and lawful authority of council, and that is a pretty broad authority, then that action has legal authority. So you can direct your CAO to put up Christmas lights in certain configurations, as long as they're not profane. And so that's within your authority. You can also, of course, direct your administration to look into bylaws for you, to say, look, as council, your core responsibility is setting and developing the municipality's policies, programs, bylaws, all those sorts of things. And you do that often by saying, hey, look, we want to put in place a tax incentive, for example. You know, Donna, can you please look into this, bring us back a draft bylaw, and then we'll debate it in council. That's the way that council acts. And I tell this to you because sometimes councillors, you know, in the informal organization of municipalities, they tend to do things which don't fall into one of those two categories. And that can get you into trouble. Because if you go back to basics, you only have that authority. And so if you're doing something that doesn't fall within those two buckets, it's not lawful. And the problem with that is it can create a whole host of problems, which we don't really need to get into. We will get into some of those examples as we go on. But the most important thing for council is really just to keep in mind that whenever you act, you should only ever act with whatever you're doing if it's authorized by a resolution or a bylaw. So that's what council can do. Now, maybe keep clicking for a little bit. Next. Oh yeah, this is good. Oh, back one more. Yeah, that's okay. That's okay. Now, you can only act by bylaw or resolution, but that's not the end of it. It has to be passed at an open public meeting. So, like this one, you have members of the public here in attendance. So if you pass a resolution, you pass a bylaw, that's perfect. That's the intent. But sometimes councillors can get into situations where you're in a meeting of sorts, but it doesn't really meet that public aspect. We're not talking about a camera here, that's something else, I'll talk about that later. But technically, and this is an example, if you're at the grocery store and you happen to run into Tracy and Kevin and the rest of council, and you realize we've got 5 of us here, and we might as well talk about that thing that's on the agenda 2 days from now in our regular council meeting. And I see some nods, so maybe that's happened. And when you're talking about this, you may find yourselves moving towards a decision. And you may realize that one or more of you, or all of you, have made up your minds. And then you get to this public session, and you start talking about it, and the discussion is very short, very, very short. And council makes a motion, and move on, next agenda item. And the public usually won't notice anything. But the problem is the public has been deprived of their right of open and transparent governments to listen and hear the debate. And yes, to appear as a delegation if your procedural bylaw allows for it and if they so choose, but more importantly, just to see and participate and even to know that that meeting occurred. And so I cite a case here, it's the Yellowknife Property Owners Association. Really what happened in that case was in the city of Yellowknife, council was having briefing sessions where essentially the CAO would meet with all of council and they would talk through, they would be provided with briefing notes and information. That part's okay. Administration can provide information to council and that can be done outside of council meetings. The problem was that in those meetings, council would then discuss it with administration. And of course, when you've got all your council and your CAO talking about something that's on your council agenda in a closed meeting behind closed doors, decisions are being made. And so, at the end of the day, the problem was that they weren't acting in accordance with the act. And so really the case is basically about, was this a public meeting and were they acting lawfully in accordance with the act? But the consequence of that is if you do that, and if you're at the grocery store and you come down to a decision and you come to your council meeting and you rubber stamp it, there's a question if whether or not that resolution or bylaw has lawful authority and whether or not you've met your legal requirements and your procedural fairness requirements to the public. And it could be challenged on that basis, which is not a good time because ultimately bylaw or whatever other motion or action you took is otherwise lawful. You just need to ensure you're doing it at a public council meeting. And so just a little guidance. If you run into each other, try not to talk too deeply about council business. You're always going to talk about council stuff. That's just how it works. But try to at least not really deliberate. So that's what council can do. And you remember bylaw, resolution, at a public meeting of council. Now, what can you not do? You can just leave it at this slide. I'm all over the place with these slides, so just ignore the slides. So what you cannot do is specifically do anything that within the MGA, the CAO office of the CAO is authorized to do. And that is a specific legal prohibition on all councillors. So you do not have the legal right to do anything that Donna in her office is entitled to do. Now, what is that? That's a million things. But for example, the CAO is the administrative head of the organization, which means that the CAO exercises all of the natural person powers, meaning she pays payroll, she hires people, she fires people, she opens bank accounts, she closes bank accounts, she buys and sells property, all these sorts of things. The CAO office or delegate is the only authority that's allowed to do those things, subject to anything else in the act. And so what does that mean practically? That means that as long as you're staying in your lane, you're passing your resolutions, you're passing your bylaw, you're setting the policies and programs of the municipality, all is good. But if you start going into Donna's lane, and let's say you show up at the town offices and you start directing staff, or this is an example we see all the time, someone works in public works and they're clearing snow, and the councilor just stops by and says, hey, this is a better way to do it. You know, if it's a simple observation, that's okay. But if you start making directions, you know, under the assumption that effectively I'm an elected councilor, I'm kind of the boss. You are the boss, the legislative boss. You're the boss of the legislative arm of the municipality. You're not the boss of the administrative arm. That's the CAO. And so the risk is you're acting outside the scope of your authority, and you're doing something that you have no legislative power to do. And so that is expressly prohibited by the MGA. So you can't do that. And so that's sort of at a very quick and high level, the difference between, you know, the council side of the municipality and the administration side of the municipality. Okay, any questions about that so far? Yes.
More just a clarification. So those types of input come through His Honor the Mayor
Yes.
from us to the CAO, correct?
What kinds of input?
If we think that it should be shoveled from east to west instead of north to south, that's something that is discussed and decided upon through Mr. Mayor, and then put it.
That's one way to do it.
Like.
Yeah, for sure.
Seems to make sense. Okay.
Yeah, so I mean, those kinds of concerns, what you can do is you can debate them in council, and then you can make a motion. You know, sometimes it's just an informal discussion, and the CAO hears it, and then things happen. That happens all the time. So you don't literally need to order your CAO through resolution to do things all the time. That's just impractical. But if there's a very specific concern like that, certainly it's a lawful way to do it is you say, you know, okay, the mayor is going to have a discussion with Donna and you know, direct her on that basis. Now, technically, you can also, you know, authorize the mayor to, through resolution, to go and deal with Donna on certain things. You can do that as well. So, yes. In response to your question, that's the right way.
So I have a question for you.
Yep.
Get it out in the air. There's a little bit of confusion here. Who's the boss?
Well, like I said, there's two bosses. Yep. There is the legislative boss, which is all of you, and there's the administrative boss. So what do you mean?
Where does the mayor step into this?
That's a good question. So what is the role of the mayor? So the mayor is, you know, when you boil it right down, the mayor is a council, effectively. He has one vote, and, you know, votes carry the day ultimately in council chambers. But the mayor also has other responsibilities, informal responsibilities that are just sort of political realities in Alberta. So typically the mayor is the advocate for the agenda of council. So in public, even if you have a mayor who's not directly, hasn't I mean, it's uncommon you're gonna have a mayor who's completely opposed to the general agenda of council. That doesn't happen very often. So, but, you know, even if the mayor is 100% on board with one thing or another, in public, the mayor is generally going to encourage and support that agenda. The mayor is going to be the key liaison to the CAO, typically speaking. And so again, council will focus, you know, hey, we want this issue discussed with administration, and that will go through your mayor to the CAO. And the reason for that is simply because, again, council can only act through bylaw resolution. So if one of you just goes off and says, hey, Donna, what about, you know, shoveling the snow or whatever? Again, there's no legal authority to that, but there also might not even be sort of the informal indication that council is supportive of that request. And so if it's coming from the mayor, then at least there's an indication that council generally supports this, and the mayor can communicate that to the administration. So that's the role of the mayor. Again, they also have other duties, like they sign bylaws. By default, they have signing authority to check. So that's
I think what everybody's gonna get here, Andrew, if I can kind of cut to the chase a little bit, is that there's a big misconception that I can go into the CEO's office and direct her to do things.
just without any backup authorization.
Correct.
So everything that I've said here tonight would indicate that is false. So you have no authority to do that. None of you have that authority, including me.
Correct.
But if
And that's-
council has made and discussed and made the resolutions and everything, mayor accepts it, then he can take that information to the CAO.
Yeah, absolutely. Yeah. So technically, that doesn't even have to be to the mayor. That could just be a broad, general, you know, like I said, if you want to pass a certain bylaw, you're going to pass a motion saying, direct administration to do X or Y, right? And your administration is going to do that. So the mayor is, again,
1 in 5.
1 of 5. That's right. Yes.
And typically the CEO's in the council chambers with you, so I'm hearing it from all of you.
Right.
9 times out of 10, we've discussed it. So the resolution can be direct administration to, or depending on the CEO's research and the team's research, we may defer it to the next council meeting so we can study it, or we may have an answer that evening that we can accomplish it or not accomplish it, and the reasons why. So we're in the chambers most of the time anyway.
I think if I can just give an example, so in my opinion, and I believe I'm right when I say this, is that, you know, I go down the street and I see there's stop signs knocked down. And I say, I go in there, Donna, you get guys out there right now and you put that sign up there. I can't do that. I can say, gee, Donna, that sign's down there, you know, just telling you. But I can't tell her to go and do something. And there's a big misconception, I think, through all the residents in town, that I can, you know, run that show.
Yeah, so that's a great example, yeah. And the way you separated that is also a great example. You have the same ability to tell Donna, hey, there's a problem over there, that literally anyone else in town does.
Correct.
And the CEO welcomes that.
Does that answer your guys' question?
Not really.
No, but.
Well, I'm here, so if you have.
Okay, so we're sitting in a meeting here, we call a resolution, we do our discussion and everything. Donna hears it, everybody else hears it, we all vote on it. Then it's up to him to take it to Donna, okay?
No, not necessarily, no. It's.
Well, it's passed and it's recorded and then she does her thing.
Yeah.
I think where some of the misconceptions of what you're talking about is you're not the boss. But technically, you're the boss if it's been passed through council, through resolution.
What do you mean by taking it to Donna? Another day in her office? Like, is it
No, just
generally-
taking the resolution to,
If it doesn't come to pass, you mean, like, if it isn't automatically done.
So maybe let's just use an example, because I think that would be more helpful. So, let's say we're talking about these stop signs. Somebody comes into the council meeting and sort of, they were talking about something else as a delegation, but they said, by the way, council, are you aware of this major problem that all the stop signs in town are knocked over? And, you know, and so council says, oh my God, well, we need to fix that, you know? And so Donna's sitting right there, administration is sitting right there. And, you know, I think 99% of the time, what would happen is they'd say, yeah, we're on it, we'll fix it, that's fine. You wouldn't need to pass a resolution. But let's say you did. Let's say you said, I'm gonna make a motion, I'd like to pass a resolution directing administration to go tomorrow and ensure that all the stop signs in town are back up, fully operational. If you did that, the mayor has no role in that, and because just procedurally, they've got the resolution. In fact, they probably will write the resolution down into the minutes. They've got it. Donna's gonna have it. She has it that second, literally, because they created it. And then that basically transfers into the administration's discretion to carry out. When I say discretion, what I mean is, as CAO, you have to do a million different things. And so absolutely that's a new thing on her plate to get done that next day, right? But she's gonna do it when she can do it, kind of thing. So, but just to clarify, I think there is some confusion there because the mayor doesn't have that role.
But the resolution would be voted on.
Always.
Yes, so if 4 of us said, nah, leave them laying over, and 1 said, no, fix them, they're gonna stay laid over.
That's right. Well, or at least the resolution.
I
But
mean,
there is a vote,
Yeah,
there
I mean,
is
I
a
do have
vote.
a special relationship in that I talk to her one of the things, right?
Yes.
Whereas maybe a council with it, and then if something comes up, I should share it with the rest of them. But-
Yes, and that's the informal part about being a mayor, right? You are a figurehead.
Yeah.
And you have sort of ceremonial informal duties, yeah, but do you have actual legal legislative power above the others? No.
No, I don't know, that's a big misconception. for
Okay.
sure.
All right, well, hopefully we've rectified that.
I did notice that in the wording yesterday, that council has 1 employee, or, so it wasn't here, but you know what I mean, it was always said council.
But Daryl's part of council.
100%, yes,
Yeah.
agreed, yeah. Above.
Well, thank you, I'm clear on that.
Yeah, and so that's actually, so, you know, one of the, segueing back into what we were talking about, the CAO has this authority to do all these various things the council does not. One of the things that the CAO does have natural authority to do, the council does not, unless you vote on it, is instruct municipal legal counsel. And so, all municipalities generally appoint legal counsel. We're here because there's a million different issues that come up all the time that a municipality as a corporation needs advice on. And so that's what we do. We help with all these sorts of things. And, when one of those million small or large problems comes up, as the CAO or delegate, right, administration are the ones who are empowered just by virtue of the CAO office to contact me. Donna can call me up and ask me for a legal opinion on something, and she's authorized to do that. Now, I want to be clear, municipal legal counsel, I do not act for Donna, I don't act for any member of administration, and I don't act for you individually. I act for the town as a whole. So I only serve one person's interests, and that's this municipal corporation at the end of the day. And that's important in certain situations, like when, there's something that might affect the CAO differently than council, these sorts of things. But the important point to recognize as council here is that you always have access to me. But you can't just randomly call me up. I've had that happen where mostly new councilors just think, well, they find my number and then they think they can call me at any time and ask me questions. And I'm happy to speak to you, but I always kind of have to ask, just want to be clear, was this authorized by a resolution of council? And a lot of times it wasn't. So, and that's a problem because then it's technically an unauthorized expenditure when the town ends up paying for fees. And as we'll get to, unauthorized expenditures after a certain amount of time mean you're automatically disqualified. So don't contact me unless you're authorized to contact me by Donna or more importantly by council. And so if there's a question, and one of the questions could be, a good example of this is pecuniary interest. We'll talk about that very shortly. Let's say there's a question in council, somebody thinks somebody has a pecuniary interest, somebody doesn't think they have a pecuniary interest. Well, who decides? Well, usually what you do is you say, Donna, what do we do? And Donna will say, okay, well, let's just put this aside for the next council meeting and we'll call it. And Andrew will give us an opinion, we'll go in closed session, we'll talk about it, and then we'll go from there. So that's an example of where you could just basically, Donna would then be contacting me, but you could also say, let's pass a resolution authorizing the mayor to contact legal counsel, and that's the resolution that you would pass. And then, you know, the mayor would phone me and I would give my legal opinion on it. And then the mayor would bring it back to council. So that's an example of where you can basically go through the mayor. But again, it has to be authorized. All right. Anything else on those kind of broad points? All right. So what I think we're going to jump to now is, did George Cuff talk about commissioners, the fact that all of the councillors are commissioners? No? Okay, all right. So you are all now commissioner of oaths by virtue of your office. You're commissioners as long as you hold office. A commissioner is someone who can, just like I did with my stamp, I notarize things and commission things, and it gives legal authority to documents. Basically, it marks it as a true copy, it marks it as a valid document, whatever. Now, because you're a councillor, yes, technically you can do this. Should you do this? Most of the time, no. Because, you know, people may come to you with a whole bunch of random things on papers and say, hey, you're a commissioner, can you sign off on this? And the safe answer is, you know, if it's your brother and you're looking at it and he just needs his passport notarized or something, sure, no problem. You can do that as long as you kind of read the booklet before to understand what you're doing. But if it's somebody who you don't know and you don't understand the document that you've been handed, you should never commission that thing. And the reason is simply because there's certain people out there who believe that the laws of this country do not apply to them, quite literally, or that there are alternative sets of laws. And they ask people to commission documents who then file them with the courts. And they cause no end of headache for lawyers and judges, and they really just rack costs up and clog up the courts. So, general advice, never ever commission it. That's good advice, except if you're very confident in the document and you know the person very well and you understand very well what you're commissioning. So that's just a side note because you are all commissioners. So something to keep in mind going forward.
There is a question. Oh, sorry. Go ahead. Just for an instance, somebody came and has a letter
Yeah.
stating that their child is traveling with so-and-so and so, and it's okay to take him out of the country.
I would never commission that. I don't know who those people are. I don't know where they are. I don't know who they're taking these kids. Whose kids are these?
I mean, it happened to me because I had to get one for my daughter to travel with somebody else.
Yeah, yeah. Oh, okay. So,
Okay, but no, so if you know the people,
yeah.
would that be okay?
Yeah, I mean, if you know, but I mean, in those situations, again, you just need to do the standard checks and balances. Do you know all those people?
Well,
You know.
I mean, I also know of another instance where a father was asking for this, but he didn't have legal custody of children.
Precisely. And so that's what I mean, right?
So you have to be very careful then on who, like,
Yeah.
just a simple thing like, oh yes, they could travel, but
Yeah, because then they can just take the kids and run. And
Yeah.
then you've got a big problem on your hands when they ask, who is this person who commissioned this?
yeah.
And you said, I don't know, and then it's you.
Yeah.
So that's just better to not do that. Yeah. Even if you know most of the people, right? It's just, you know, what you can.
You never know what goes on behind that family dynamics behind closed doors.
That's right. And, you know, there's people who have businesses as notary publics, right? So you can basically say, look, I don't, out of a general rule, I don't commission things unless I 110% know. You can go down to wherever and they'll commission it for you, no problem. So for a very minute fee usually. So that's a better example. Yeah.
Sorry, I was just gonna ask, so who all could we send to a commissioner of oaths other than a lawyer? Or like, what are all the examples or some of the examples of common people who can commission?
Okay, so I think, well, it's municipal councilors, it's barrister and solicitors, might be provincial politicians as well, might be judges maybe, I'm not sure about that one. But it's things like that, it's public offices. Yeah.
Sorry, I was just looking at people coming to the
I
office.
know a lot of people, like in town, get insurance, the insurance agents, a lot of them are commissioner roles.
Yeah, anyone could actually become a commissioner of those. Like, yeah, yeah, it's very easy.
So 4 years ago, when I was sworn in, I did take the course. I can't remember if it was online, because I know I have a binder of paperwork about it. And then our lawyer at that time asked me a few questions about it to make sure I understood what I was doing, and said, go ahead. So I've been doing it for the town for some time.
Yeah, and so that's, so literally, that's the other thing, is that you've been elected a councillor, then suddenly you can do this other thing. But anyone can go and do this. And I just did the training for a whole bunch of some clients, basically. And like, it's just that. It's just, have you read this book? Yeah, I've read the book. Okay, well, you're good to go. So, and it's a free book online too, on the Covenant Holberg's website. So it's not difficult or expensive things.
So do you recommend us as counselors going online and doing it then?
I recommend that if you are going to use your commissioner of oaths ever, you should read that booklet before you.
Be knowledgeable about it.
Yeah.
It's not just a signature.
Yeah, exactly, yeah. Because there also are certain rules and things, it's not complicated, but there are certain things you should know, so
We'll
yes.
just let Counselor Messon do it.
No, I'll share the ability.
All right, that moves us to sort of our liability section of today. We're starting with, okay, now you can move slides. Let's go to slide 24, please. Perfect, okay. So pecuniary interests, has this ever popped up?
We bring it up every meeting, yeah.
Every single meeting, okay. Oh, it's like a.
Yeah, it's standard on our.
Perfect, all right. So pecuniary interest then, as most of you will probably be aware, a counselor will have a pecuniary interest in a matter if it could monetarily affect a counselor or an employer or their family, effectively. And you can go to the next slide. It can monetarily affect you even if it's through a corporation. So you can't just say, well, it's my business that's monetarily affected, so that doesn't mean me. No, you can't quite do that. It's a person, including if you own shares in a corporation and it monetarily benefits that corporation. So the important part about this is, well, before I get there are certain exceptions for this. So the significant thing about this is if you fail to comply with the sections on pecuniary interest, which is even as simple as just not declaring that you have a pecuniary interest, you are automatically disqualified from council. There's no taking that back. Now, there are certain exceptions for what constitutes a monetary interest, and that's simple things like, well, you know, I, as a counselor, have a general financial, I am monetarily affected by the fact that you're raising property taxes because I live in town. That's not a pecuniary interest, nor is it a pecuniary interest because your family lives in town and is affected by that. Because if that were the case, then what you would do would be literally impossible. And so those sorts of things, you know, there's a whole slew of those sorts of exceptions, which you can always look at to ensure that, you know, something doesn't fall into there. One more, please. Now, the general process, what's your general process actually for pecuniary interests?
Also, before when we do an agenda, we ask if anybody has any pecuniary interest in anything in the meeting.
Okay.
And so then if they do, they declare it, and then they would absolve from any discussion on it.
Perfect. So that's the right way to do it. So basically, Section 172 of the Act says you must disclose the general nature of the pecuniary interest before any discussion and have that recorded in the minutes. So it's a good way to do it at the beginning of the meeting. These are all the things on the agenda. Are there anything that we're going to talk about that's pecuniary interest for anyone? Now, it doesn't actually have to be done at the beginning of the meeting. It just has to be done before you discuss that specific thing. So let's say, you know, you get to suddenly a question of, I don't know, somebody's asked for property tax forgiveness. and it turns out that one of the counselors is related to this person, and it falls within the definition of family in the MGA. Well, at that moment, even if you hadn't asked about that before, you then need to say, okay, everyone, just so you know, this is my cousin. And, then they'll say, okay, so you're saying you have pecuniary interest, and you say yes. And that means you have to abstain from the discussion on that specific matter. And not only do you have to abstain from the discussion, but you have to leave the room. There's certain exceptions on that. But generally speaking, you have to leave the room. So if that comes up, the simple rule is disclose, confirm you have one, get up, leave the room. Someone needs to tell you once the discussion and the voting is done, and then you come back into the room. You can't just miss the whole meeting just because you were like, well, you have to get up and do that, Councilor. So that's the way to deal with pecuniary interests. Now, the consequence, as I mentioned, is that if you fail to abide by those rules, you could lead to disqualification. I say could lead because ultimately what would happen is the court would have to determine if there actually was a disqualification, meaning was this actually a pecuniary interest? Were you monetarily affected? If they make that, and there's a whole bunch of decisions that basically say this person was disqualified because they had pecuniary interest, so the first issue for the court to decide is whether they had pecuniary interest. So if you have a pecuniary interest, then you automatically are disqualified. The other possible consequence is that if a councillor has a pecuniary interest in an agreement between the municipality and some other party, it could mean the municipality could just get out of it. They're subject to certain exceptions for like emergency services and these sorts of things. But I mean, think of that as an escape hatch for the town generally, right? Suddenly it turns out, well, this councillor voted in favor of entering into some specific agreement that benefited them monetarily, didn't disclose it. The rest of council finds out, this is an outrage, the town's outraged, and yet, contract law is contract law for acceptance, you can't get out of it. In those situations, the MGA creates an exception which says, well, in those situations, you can get out of it, and you are no longer bound by that contract. So it's an exception to basic contract principles, but obviously that creates a lot of upheaval. So again, that's a pretty significant consequence of not disclosing a pecuniary interest. Yeah.
Question. What happens if you have a relative that also works for the town and the subject of wages and everything comes up? Where do you, as councillors, stand on that?
Well, it depends on the relative. So there's a definition of family within the MGA. And so the person has to fall within that definition. So if we're talking about a really close relative, like a daughter or a son or something like that. Grandson? Yeah, that would count, that for sure. So in those situations, I'd have to check if it actually falls into one of the exceptions. I don't know. I don't remember, I'd have to check. My instinctual response is to say, if it doesn't fall into one of those exceptions, then you shouldn't hold on that. If it does fall into one of those exceptions, then you have an out, basically. But it also depends on what you're voting on, right? Because if you're just passing your budget, well, no, there's no pecuniary interest in it. Yeah. So a different situation might be if you have, do you have any unionized?
Yeah.
Okay. Yes. Okay. So in those situations, if your grandson, let's say, is a member of the collective of the bargaining unit, in those situations, if you are, again, I'd have to confirm that there's not that if an exclusion applies or not. But let's say it doesn't apply. If you vote on the approved package to your bargaining committee, saying, yeah, we'll go up to 9% wage increase or whatever, maybe that's pecuniary interest as long as that, because you're approving an increase that will monetarily affect your, right? So that's a problem. And so in those situations, when you have something that's really specific, because that's just basically a bucket of money that goes directly to wages. The general budget is different, right? So So that could be a situation where you do have pecuniary interest. Thank you. You're welcome. All right. Next slide, please. All right. So, here are just some examples, basically. And spouse of counselors, employee of municipality, yeah. So I'm guessing that there is no exception then, based on my own slides. And so this is sort of the segue into disqualification. So, have you ever had a counselor disqualified here?
Not yet.
Not yet. Always time. Always time.
I think she looked at me.
Well, you get to know me now.
Andrew, if I may.
Yeah.
One of the biggest headaches that CEOs have is your number one bullet. Proposed amendments to land use bylaw to change the district applicable to land lot adjacent to council's land. You look at Thorhill, Chestermere, Crow's Nest Pass, like all the ones I've been at. Maybe I have a good problem. But anyway, they've all absolutely ignored the land use bylaw. And it is one that will get a council into the biggest trouble.
Yeah.
And it's one where I will say administration can save council by looking after some of that stuff and not worrying about it. But it also happened in the Duke too, where it was just a giant mess. There's a couple of towns in Alberta and 2 in Saskatchewan where councillors went to jail.
Wow. Yeah. So that's a great example. And the reason why it's so difficult is because land use bylaw changes can be very difficult to predict the effect sometimes. And sometimes, you'll think, oh, well, we're just changing this zone because we want to, facilitate commercial development or whatever. Turns out you own a whole bunch of property in that zone and suddenly the values skyrocketed. You turn around the next day and you sell to developers. That's a great example of a pecuniary interest. If you participated in that debate, if you voted on that, not only are you disqualified, but that's, there's some arguments for some of the other torts that could be held against councillors, like misfeasance in public office and those sorts of things. Difficult to prove those, but just as an example, and it's not, the reason why it's difficult is because it's not clear on the face of it. It's pretty easy to say, I'm approving my grandson an extra 5% because I think he's a hardworking lad. But it's a totally different thing to say, I'm really going to advocate strongly for commercial development in this corner of town and not explain why. And it turns out because you own, 40 lots there or whatever. So that is a good point. Very, very sneaky problem to have. Okay, so good segue into disqualification. So since you've never dealt with it, this is perfect. So disqualification, the process for it is set out in sections 175 to 179. The basic principles are this. There is a list of things. If one or more of those things happen, or those grounds have been met as a counselor, by an individual counselor, I should clarify, you are automatically disqualified. There's no appeal. There's no, I didn't mean to. That comes into effect later. We'll talk about that. But just the question is black and white. And I'll use an example. One of the provisions is that you owe a debt over $500 to the municipality for more than 90 days as a counselor. And a debt that could include property taxes. But let's just say it's another kind of debt, like whatever they did for you, and you owe them $1,000 for some kind of service, and you just haven't paid it because who gets around to paying your bills? And a month ticks by, 2 months tick by, suddenly it's been more than 90 days. You don't realize it, but you've just been disqualified from council. Now, so then what happens then? Big question. 172 is what you look at. Just want to check, is there anything? No, okay, there's no other slides about this, so I'll just talk. So 175, sorry, is what I'm talking about. 175 states a counselor that is disqualified must resign immediately. Must. There's no, if I feel like it, I'll resign. may resign. No, it is must, mandatory language. Now, because, the legislature has recognized that lots of councillors just won't resign, they've given the municipality and electors a way to force them to be removed from office. So the first step, if you discover that one of your councillors is disqualified, you notify them in a council meeting. And you say, look, this is brought to our attention. It appears that you are disqualified, and you would essentially motion that the councillor resign from their office as a result of their disqualification. Then it's just up to the individual councillor to say no or yes. If they say no, then what can happen is council can basically make the decision to direct their legal counsel to apply to court for an order requiring that councillor to vacate their office and declaring them to be disqualified. But that's not just for the municipality's lawyer. An elector, just a resident of the municipality, can pay a little bit of money into court, go get their own lawyer, or even file the application themselves and ask the court to disqualify a councillor. So that can happen whether or not, so let's say, one of your councillors, he forgets to pay a debt and then pays it on the 91st day, and you're like, that's stupid, whatever, it was just a mistake, we're not gonna worry about it. But suddenly this gets posted on Facebook and it becomes a nightmare. Somebody actually pays the money into court, manages to file the application, you gotta deal with the application. And it's not the actual town that would be involved in that application, especially if it's filed by the elector. It would just be the individual councillor. And so, there's a lot of permutations of that kind of a situation. But if that councillor is legitimately disqualified, effectively you're on your own for your legal fees in that situation because you had the opportunity to resign. And so if you want to defend against it, you go get a lawyer and basically, hope you can properly defend against it. Now, in most cases, it's not going to be an elector because people just don't want to pay money for that sort of thing. It's usually going to be the municipality. And if you have a councillor who is disqualified, I would say that as lawfully elected officials, you generally would have a duty to your municipality to say, look, we still think you should resign because you have been disqualified. According to the act, you acted contrary to your office, and the act says that you should basically step down. And I've been in that situation myself, and not as a councillor, obviously, or a CAO. And the advice we give is, look, the right thing to do here is to take steps to have this person removed. Specifics aside, in this situation, to show your residents that all councillors are equally subject to the laws of the land, they should be disqualified, removed from office. And so you should make that application. And so then what happens? We're in court. Whoever brings the application, we're in court. The councillor is not agreeing to it. They are fighting it every step of the way. So at that point, the court applies a two-step test. The first test is to determine whether or not one of the grounds of disqualification have been met. So going back to that debt example, it's just a simple fact of proving in evidence if the person actually owed that debt for more than 90 days. That's it. It's just a black and white thing. There's one of property taxes. The property taxes one is that you actually have to have unpaid arrears. So it's not just late current year taxes, it is arrears, meaning they tick over into the next year. If you let your property taxes go that long and you don't pay them, you're disqualified. So that's the first step. Basically, everyone files their evidence and you prove to the court that the person has met that ground of disqualification. Once you've done that, you then have the court able to exercise their discretion to determine, well, in this specific circumstances of the case, I think the person should be removed from office, or I think this person, justice of the case demands that they remain in office. And that discretion is usually exercised based on sort of the smell test, right? Like, was this intentional? Did they intentionally not pay their property taxes? Is the evidence pretty clear that they were regularly not paying, they knew, and they just decided not to pay? Those sorts of things. Or did they refuse to pay this debt or whatever, and it went on for a long time? So in those situations, the court will be more likely to say, no, you are truly disqualified, move from office, hold a by-election, fill that seat. But if it's innocent, like the person somehow doesn't pay the debt, it's 91 days, it's truly inadvertent, and in those situations, the court might say, they paid on the 91st day, they've got 3 years left in their term, I don't think it's a big deal, we're just going to protect their seat. So that is ultimately up to the court. Now, I'll tell two stories. I'll remove the names of the municipalities, and I certainly won't name any names, but I've done 2 disqualification applications where the court came down on opposite ends of that. And it's a great indication of how they would exercise that discretion. So, the first story is where basically this councillor in this municipality, he somehow forgot to pay his property taxes for about 8 months. And the municipality would send out notices saying, hey, guess what? Just like a month ago, you owe some property taxes. And hey, if you don't pay in a month, you're going to pay some penalties. Well, I didn't get that one. Well, another month went by, you didn't get that one either. You owned a bunch of property, you paid some, you didn't pay others. That's from June. This continues on all the way into December. Weirdly enough, he paid some property taxes in October, but not all. It goes to January 1st. Nothing happens, he still hasn't paid. Those taxes become arrears. That means you are disqualified. This councillor still doesn't pay. 2 months later, somebody, an elector, provides some information to council at a council meeting that this councillor just happened to owe a bunch of property taxes, and they were arrears. That, of course, created an uproar. It was very political, and he refused to resign. And he said, that wasn't my fault, it was inadvertent, I didn't know. That was also at the same time of the Canada Post strike. He said, I mailed the check didn't arrive. So that, of course, gets the council. Council did the right thing and said, look, we think that you are disqualified, you're refusing to resign, we're going to direct our lawyers to file an application. So I filed the application. The mayor, in that case, retained a lawyer. And me and this lawyer, we went in front of the judge and we said our bits. And basically the point I made was, if you look at all the facts, it's pretty clear that this person ought to have known that they owed property taxes. And this person was a direct councillor. And so you have to sort of assign a certain level of knowledge. And the other lawyer said, well, yeah, but he's got that, he's got 8 months left in his term. It was a small amount. And the important point here, though, is that as soon as he learned that this was in February, that he had property taxes to pay, he paid it, just like that. And so that's technically that doesn't fix it. You're still disqualified. But what the court said at the end of the day is, I don't really think this is so egregious of a situation that we should actually exercise my discretion to remove this person from council. And actually, I can tell you the real reason why she found it that way is because she was obsessed with the Canada Post strike. And, who can tell anything when you put something in the mail and it just disappears? And there was no evidence on that. So that's a separate note of my personal frustration. But it's just an example of, when you've got a situation like that, you have to be careful, but you can be disqualified and the court can say, look, it's really not that bad. And that was probably the right decision. At the end of the day, I think that's the right decision. Now, another example, and again, if you read any of this stuff in the newspapers, local newspapers or not, that's fine, it's public record. All of this is public record, but I'm still running names. This was one where this councillor basically, a very different situation. He had a bunch of issues, I'll say, with people within the town office, and he was being notified about the 3rd or 4th serious issue that he had, this councillor, and he got really upset And when you left the office building, instead of most of us do, we just turn the knob, or if it's a push door, we just push it with our hands and we walk out. Well, this guy kicked the door down with a giant Doc Martens boots. It was an old security door and he broke the door entirely. So it was a double security door and the municipality had to fork up like 10 grand to replace this door. So this person, it was on security footage and he admitted in council meetings that he did it. And the CAO, after a certain point of time, just sent them an invoice and just said, pay the invoice, fix the door. We fixed it. It was 10K, fix it. And this person sort of kept on bringing this up in council meetings and saying, well, you know, I was upset and I know I'll try to do better. And how about I pay you half, you know, and these sorts of things. So he admitted that he owed this very clearly. So it went on and went on and went on. And ultimately, council said, well, this guy hasn't paid this invoice and it's been like a year. And, you know, he's just not really doing his job. And so what's going on here? And so they sought an opinion. I said, yeah, he's disqualified. He was disqualified the minute he hadn't paid that debt in 90 days. And so we brought the application. And at the application, the guy didn't even show up, didn't contest it because he knew it was a waste of time, didn't want to try to contest it. And the court rightfully said, well, I mean, this is ridiculous. Like you damage public property, you complain about it on social media, and then you don't even pay for it. Absolutely no, not only is he disqualified, but I have no way I'm exercising my discretion. He's out. Vacated seat and hold a file action. So in those situations, you can tell by the sniff test for the most part that this doesn't smell good. This isn't going to look good to the court, and he's going to be disqualified. So all of that is to say, read that section, read the disqualification section at least, and ensure that nobody here strays into that route because you've been elected for a reason. So keep your seats. And then Donna never has to call me about it. All right. So what I'm going to do now is we're just going to jump right to personal liability of counselors. So slide 39. Okay. Next slide. So there's really, again, this is kind of the topic of liability, how things you need to watch for. And one of the things is unauthorized expenditures. So if you vote to spend borrowed money for a purpose other than that which is borrowed, if you vote to spend money on a grant, if you vote to spend money obtained in a grant for a purpose other than that which the grant was given, or you vote in favor of a loan, borrowing, or guarantee which exceeds the municipality's debt limit, that's an unauthorized expenditure, and you can technically be liable personally for that amount. So you just want to be careful. And you know, in almost all of those cases, I mean, the CA is going to warn you if anything like that is coming anywhere close. But so just pay attention to your administration, and you really want to be careful because nobody wants to pay out of pocket for something that might be done in you know, good faith, but just, you know, incorrectly. Now, the starting point, you can go one slide, another slide, perfect. So counselors have basically a nearly perfect liability protection in the Act, which says what the slide says. Basically, counselors are not liable for loss or damage caused by anything said or done or admitted to be done in good faith with performance or intended performance of their functions, duties, or powers under the MGA. So what does that mean? That means if you're sitting as a counselor, you're acting in good faith, you're passing motions and policies and bylaws, you're not liable for something that comes from that. So example, you know, you pass a land use bylaw and it affects property values in town. You've had debate on it, you've held public hearings, it's gonna change something. There's going to be an impact and it may impact property values. Are you personally liable for the reduction or increase in property values? No, you are not, because you acted in good faith, you legislated, and you have perfect statutory protection and common law, but that's not what we're talking about. So that's the starting point. But there is a very specific exception, and that is not a defense, and this is intentionally carved out, for an action in defamation. So, does anybody know what defamation is? You don't.
You just can't say bad things about a person.
Yes, but it's a little nuanced. So defamation is a tort, like negligence. It's not just bad things though, because the reality is there is constitutionally protected freedom of speech in this country, and you can insult people. That's true. You can say something that is on the level of an insult, and there's no way to actually action that. But there's a fine line, because when you stray from an insult into saying something that damages someone's reputation in the eyes of someone else, that's defamation. And so what that means is basically, I'll give you an example. That's a great way to explain defamation. So I see the mayor. I come into town, and I know the mayor lives over on that side of town. I don't know why, but I see him walking out of somebody's sort of rear porch. And that's weird. It's like 3 p.m. Everybody should be at work or school or something. I don't know what he's doing in there. Comes out, he's carrying a massive TV. I'm thinking, that's not his house, that's not his TV, something is weird. So I'm a good law-abiding citizen, I call the RCMP. I don't know if that's the mayor, but I think that's the mayor, and I think he's stealing a TV. So in that situation, what I've done is I have published a statement. I've made a statement. I've called up the RCMP and I've spoken to them. Published a statement can be written or verbal. I have identified the mayor, because I'm in the town and I've said, hey, it's the mayor. They obviously know I'm talking about the mayor of the town of Thorsby. And I've said, he is stealing a TV. It is always defamatory to say someone is committing criminal activity. So I have defamed the mayor. There is no question. But, and so that's the basic levels of the torts. That it doesn't end there though. There are defenses to defamation. You can flip the slide, you will see them. So once you've established that you've defamed someone, or that you've been defamed rather, it then turns to the question of, okay, so I said these things, I published it, identified the mayor, and it was defamatory. But do I have the benefit of the defense? And if I do have the benefit of the defense, I am not liable. First defense is truth. In that case, were you stealing the TV? No? Okay, he wasn't. All right, so that one doesn't apply. Now, truth is tricky, because truth is not just black and white. It's easy to say, he was holding a piece of red paper, and if the paper was not red, then it was false. It's more difficult to say something like, here's a good example. I don't think the councillors are acting in the best interest of the town. That's a pretty loaded statement. What does that mean? Is there some truth in that? There might be, maybe, depending on all the million different factual circumstances you have to think about. Or it could be that there's, when you look at it as a whole, it's not substantially true. It's not a true statement, so there's not a defense there. But even if it's something isn't black or white, and so truth wouldn't apply, you get into the way more technical defenses. Fair comment. That's even worse. That is a statement of opinion that is reasonably stated based on true facts. That was not made with malice. So what does that mean in plain English? Basically, if I say something that's my opinion, and it's based on true facts. So I'll give you the actual example that comes from case law. There's a decision about this, which basically somebody drew a political cartoon about a federal politician, I believe, or maybe provincial from BC, and it pictured him as a very large man looming over a bunch of flies. And he had chopsticks, or maybe he was picking off their wings with his fingers. And basically, the flies were labeled as welfare recipients, because this politician was very much in favor of undermining the Social Security net, removing CPP, EI, all those sorts of things. And so the question was, was I defamed, basically? And the politician sued. And the question was, did fair comment apply? And the court found that it did. Because you have to, whenever you make a statement of opinion, you have to first ask, well, what are the facts underlying this statement? And in that case, the facts were, this politician had a long, transparent record of trying to undermine the Social Security net, of trying to say, we need to defund all these sorts of things. We need to remove social assistance. And he was transparent, and that was his record. And so when they basically dramatized that in a cartoon form, They said, first question, is that based on true facts? Yeah, there's 10 years of you making speeches about, how terrible this social security net is and how you need to remove it. So absolutely, that's a true starting point. But that's not the end of it. Then you have to say, but is this opinion reasonable, right? Because you can be unreasonable. You could, picking wings off flies, yeah, okay, it's an uncomfortable, it's a hurtful image, but it's not really unreasonable. And that's what the court found. They said, okay, yeah, that is reasonable because a normal person, a reasonable, normal person could express that opinion that basically this guy treats welfare recipients like flies. And, the record found that was substantiated. But you can express an unreasonable opinion about something that is true. An example I gave in different council orientation on that was, let's say somebody comes in, you deal with lots of unsightly property? Yeah? Okay, good. You're familiar. So if you get a review by council, it comes back to council, and council has to say, okay, well, we've heard this person's, pieces. And in those situations, what sometimes happens is the property owner says, it's not a messy yard, it's art. It's my art. And so in those situations, council then basically needs to decide, well, is it art? An example could be you're sitting there, the person says, this is all my art. It's just a pile of garbage, like literal garbage. They're just big black bins full of stuff. And one counselor says, no, sir, it is not art. It is literal trash. And maybe this person actually is an artist and this was some sort of modern art installation. Well, in that case, when you say that, that's potentially defamatory, right? Because it's calling this person's art literal trash, which is defamatory. That's okay, right? But if you go beyond that and you say, well, not only was that trash, but I've never seen, such horrible art in my entire life or something like that, that's probably exceeding what is a reasonable opinion. And so in those situations, you've gone beyond the realms of that defense, and so you could still be outlawed. Finally, absolute privilege is only for parliamentary politicians, so federal and provincial. When they're in the House, they can say basically anything they want that maintains House decorum, and they cannot be sued for defamation. Qualified privilege is a similar thing. Basically, if you're making a statement, you have a legal interest to make that statement, and the person receiving it has a legal interest to receive it, then you can have that statement even if it's defamatory, protected by qualified privilege. So this comes up in your lives as municipal councillors. You do have the benefit of qualified privilege. Now, there's some Supreme Court of Canada authority which basically says statements made during council meetings are likely privilege. That doesn't mean you should go and defame everyone while you're in your council meetings, because there is still an exception to that. There's two exceptions. And also, the statement has to be in the course of your official duties. So you can't just sit here and go off on someone and then say, well, the lawyer said I'm immune because I'm in council chambers. That's not what I'm saying. What I'm saying is, if you're in council chambers and you say something that's defamatory, then basically it has to be made in the course of your official duties. So a good example would be, developer comes into town, they want to build some monstrosity, council is not on board. It's okay to talk about that and voice your dissent and how you are really against that. But you shouldn't then say, and also, I heard this guy's a scumbag because he owns a whole bunch of other businesses, and maybe they aren't legitimate, and all these sorts of things. Suddenly, you've strayed way beyond the realm of your official duties into the realm of pure defamation. And so what you've done is you've either made that statement maliciously, which is made with an intent to harm, or you've exceeded the privilege. You've exceeded the information that you need to communicate in that instance. And so all that is to say, as councillors, try not to say anything to anybody that is defamatory. But if you do, ensure that it's related to your official duties and ensure you keep it within the scope of your official duties. Yep.
Do you find councils get into trouble being on social media?
Yes. Everyone gets into trouble on social media. Yeah, and so that's a great example. And so a good example of that is Counselor A goes on the local rant and rave and says, you know, here's this issue in town. And people are complaining about something, and they jump on and they start making comments saying, I agree, this is horrible. And when you do that, you open yourself up to pure liability and defamation, depending on what you're saying. And you know, there's also lots of other reasons not to do that, because you can undermine council's agenda, basically being a lone councillor, which can cause problems. And you're not doing anything by being on social media either. You have no legal impact. You have to act by motion or resolution or bylaw, and you do that in a council meeting. And that's where your authority lies. So stay off social media, everyone. It's just a horrible place. All right. So that's personal liability. I think I'm at 8:20. So what I'm going to do, I'm just going to go through privacy legislation, and I think I'm good. Does that sound good? All right, perfect. So if you can go ahead. Okay, perfect. Okay, so you're all likely familiar with the Freedom of Information and Protection and Privacy Act, FOIP. That has been replaced with two separate pieces of legislation, Access to Information Act and Protection of Privacy Act. So the Access to Information Act is the portion of FOIP which allows the public to get information and records that are in the possession and control of municipalities. So if you want something, you know, you contact your municipality's work coordinator or just CAO, and you say, hey, I want all documents within your possession relating to X, Y, or Z. And then they say, okay, you gotta pay us, and then we're gonna go get it. And then you might get it at some point. Well, you will at some point.
So just repeat that last part again. You may get it.
You may get it. You may get it. So why I say that is because there's exceptions to disclosure. So it depends what you ask for. You will get something back. They are obligated to respond. There's timelines. They can request extensions. Although I will add that the new Access to Information Act now has the ability of public bodies to refuse frivolous, vexatious requests. So that was never a thing before, really. So that's great news. So, but yeah, you may get it depending on what you ask for. So that's access to information. Protection of privacy, really not all that important for us today. But basically, it's just certain rules around the collection, disclosure, or use of personal information. So if you got a security camera outside the town offices, there has to be a policy, program, or reason of the municipality for that security camera. And otherwise, they can't make use of the footage. And when they make use of the footage, it has to be for whatever that policy, program, or use. Now that may seem like, whoa, what does that mean? That's difficult. But it literally means, yeah, it's to prevent theft. That's a policy reason. So if we have a theft, we can report it to the RCMP, use to discipline staff. If someone's stealing something, we catch them on camera, we can use it for all those purposes. Let's slide over.
Sorry, I just have a.
Oh, yeah.
Sorry. And just to clarify to make sure, because I know it's a misconception to some residents and developers in town, that also includes anything located within a private lot's tax roll, correct? So anything that we keep within a tax roll, it doesn't matter what it is, if it's personal information to the resident or to the business or to whomever owns that roll, we cannot give that out to the public willy-nilly.
Yeah. So yes. So the personal information contained within those documents, you would essentially redact. But like assessment information is generally disclosed.
Yeah.
So another example is kind of similar. Is subdivision applications, development permit applications. You would remove personal information, but the public has the right to access those, including like building plans and stuff like that sometimes.
The other thing too, Andrew, is when it comes under Protection of Privacy Act, and we're looking at cameras and so forth in the municipality, we have to fill out a privacy impact assessment. And it's huge to do. What are you collecting? Why are you collecting it? Where are you going to keep it? How are you going to dispose of it? What is your purpose for keeping something under 30, 60, or 90 days, depending on your policy? How are you going to release it to the RCMP? You have to have legal. It's a lovely big form.
Yeah. Yeah. So for council, and this is the important sort of the two aspects of this. There's two things that we need to talk about for your benefit. The first is that as councillors, you are an arm of the municipality, right? You're the legislative core. And that means that technically a record under your control, provided that it was provided to you for the purpose of you carrying out your duties as a councillor, could be a record under the possession and control of the municipality. So do the councillors all get town of Thorsby email addresses? Okay, so everything that goes into your email address at the town is subject to access to information requests. So you don't use that for personal, and also don't use your personal email for council business, because then someone can make the argument that they want access to your personal email, and they would probably get realistically. What about cell phones? Do you give, I just have one, no, you don't use cell phones for council business, okay? Yeah, good idea, don't, because same idea. If you're using your cell phone for council business, it might be anything on there, might be a record, and then, you know, they would have to search that to potentially get some records responsive to any point for access to information requests. Now, we can jump 2 slides ahead. It doesn't extend to just your personal records, though, or your constituency. So if you run in the election, right, and you, I don't know, had some records about people who supported you or whatever, that's all your own stuff. It's not in possession control of the municipality. If it's truly personal, your personal emails, personal text messages, personal phone device, nothing to do with your councillor duties. The town cannot say, hey, give me that, I want to look through it to see if you got anything. No. Now those don't have to be disclosed. And so, one slide over, please. So records dealing with municipalities' business. So this is just the idea that if you're storing it in your constituency office or your home, or you have something that you received from Donna, and it's in the course of your councillor duties, let's say it's a print off, it's technically a record within the possession and control of the municipality. And so if it's responsive to, a court request, you may be required to provide it. And so really the caution here is just what we talked about. Don't use any personal devices. Don't store stuff at home if you can help it. Keep everything within the municipality's possession and control, and you don't have to worry about your personal lives and your council lives. Okay, yes, and so basically, we talked a little bit about exemptions for disclosure. So when you submit an access to information request, the municipality will say, okay, so let's look at all this stuff. We got a bunch of stuff, but half of it's personal information. And so we do not have to disclose personal information. And so they will just say, well, either you can send the document back, but the entire thing's redacted, or you can just say, oh, that's generally what you do. You would redact the entire thing, or you redact certain pieces of personal information from it, or refuse to disclose other records because they meet one of the other exemptions to disclosure. And it's just a good idea to have retention policies and stuff in relation to documents that council might come into effect. And one thing, maybe this is for Don's benefit, but the new privacy legislation has a legislative requirement to publish all of your public policies online. It comes into effect within a year of June of this year. So
June coming up, yeah.
Yeah. So
Andrew, we had a situation here when we first came into the municipality that a lot of records were on. I'll just have to be careful here. We're on a former employee's computer that were erased. We lost a ton of records.
yeah. Yeah. So again, good reason to keep good policies and to not have it on personal devices. Okay. And so I guess I sort of missed but I'll talk about it without having a slide. So the most important, this is one aspect of it. When you've got documents, in your possession and control as councillors, those are subject to void, basically. So you have to be careful, separate your personal and your council lives. The other aspect of this to understand is closed session. So when you're in an open council meeting, like we are right now, members of the public can sit in the gallery and participate. But when you want to discuss something that requires you to go in closed session, that's when you have to resort to the exemptions for disclosure. And so what do I mean by that? Sometimes there's a view that you can just go in closed session when you want the public to leave the room and you want to discuss something behind closed doors. That's not how that works. The idea of closed session is that if council has to discuss something, that if a FOIA request was submitted for those documents, you would say, we're not going to disclose that because of all of these grounds that we don't have to. And so the idea is it makes no sense to force council to talk about those things, which they couldn't actually talk about, in public session. And so that's what closed session is for. So the proper way to do it is to say, we're going to go into closed session and I'm going to enumerate in the minutes the specific grounds of the Access to Information Act that we are relying upon to go into closed session. And there's loads of them. But one example is personnel matters, right? So if the CAO is bringing a employment discussion, like there's just some employment issue that she wants to update council on, you're not going to discuss employees' personal information in open session, definitely not. And so you would say, okay, motion to go into closed session, personnel matters under section 16D or whatever it is of Access to Information Act. That would go in your minutes. Everyone would leave the room. Council would discuss. You would then finish your discussion, pass a motion to leave closed session, and you would resume open council meetings. So the important point to realize is that closed sessions have to be for a reason. You always have to anchor it in a exception to disclosure. So if you're unsure what those are, take a look at the new act. There's loads. There's some new ones too, like workplace investigations, which are really heavy. Oh, you got lists. Very good. Very heavy list. So always check your list and ensure you've got that.
The other thing, Andrew, too, is when council goes into session and we have to provide some documents for them to look at. They can look at a closed session, but it's taken back by the CEO and or their designated shredded actor.
That's right. So the council also has a duty to maintain confidentiality of all information received as a councillor. And that, of course, includes the obligation within closed session. So when you're in closed session, you don't take notes, you don't text people, you don't, take notes. And if you get documents, that's right, they get shredded. It's just for informational purposes in that specific moment. And then you don't leave and go post on social media about what you discussed in closed session. You don't do that because that's specifically contrary to the act. It says you do not do that as a councillor. So that's what you do not do. Yeah. All right. I think that's my legal orientation. Thank you so much. Any last questions while I'm here? It's 8:33.
Good, Irene?
Okay. In a closed session, and one councillor is absent for whatever reason, but he's in on Zoom, is he entitled to be part of that closed session or not? Because we wouldn't know who's in that room with him.
Yes. So simple answer to your question is yes. Yes, he absolutely is. So now there's a requirement for municipalities to include provisions in their procedural bylaws which provide for attendance of electronic meetings. And so in the procedural bylaw, it will say, here's what councillors have to do to attend meetings. They need to submit a request in advance or whatever. And often you'll see a provision in there which says they have to confirm when they join the meeting that there is no one else in the room. So I would say even if that's not a procedural bylaw, you owe a duty as a councillor to do that.
We have that.
Yeah, there you go. Okay.
Oh, thank you, Andrew. And just, I guess the only other thing is that, is that, what is there, 700 sections under the MGA that's in here? That's
Yeah, it's
also-
just light reading.
Yeah.
It's just very light reading.
Can't fall asleep tonight,
Yes.
Yeah.
Appreciate it very much. Thank you.
Yes, you're very welcome. Okay, I'll let you get on with the council meeting.
Thank you.
Thank you.
Thank you.
Your worship, permission to
Yep.
stand.
A couple minutes, so just while we're sitting here, so yes, this and the course that we took yesterday are mandated in the MGA that we have to take this before we start doing our business here. So we spent a whole day yesterday and 101 other stuff, so quite a bit to it, and it's all required under the MGA.
This binder is bigger.
And, sorry, feel free to write in it, add pages, it's yours. So you don't have to return it, it's all yours at the end of the day.
Good, because I did.
Okay, yeah, go for it.
While we're waiting, I do have a question, just for, I guess, protocol. In the middle of the meeting, can we just get up and go leave? I wasn't sure I'd wait until I could catch Cindy's eye.
Yeah, no, you can just
get
just say you're leaving for a bathroom break, so yeah, just stay or whatever. All right, we'll get on this here, after this done here, and then we'll take, after this, we'll have a quick break, and then we'll get on to the second part here, so. Can I get a motion to accept the legal team, council orientation training for information?
I'll make that motion.
Thank you, all in favor? And Kevin, you're in favor? Information?
Yeah.
Okay, so we have to, one of the requirements is that,
Put my hand up for abstaining.
everybody has to,
You got one or the other.
one or the other, you're correct, just for everybody to know. And there's lots of times I'd like to say I don't want to vote, but you can't do that, you gotta vote one way or the other, so. Okay, item number 6, deputy mayor assignment. Sarah Dawn, you want to comment on that?
Thank you, Worship. Just under the executive summary, there's a bit of a change is that the deputy mayors are decided not by alphabetical order, but the amount of time spent in we live in a municipality, just so you know. So each new council, deputy mayor rotation is decided by different methods. Could be number of votes, it could be where they live, there's no rule. So what we suggested is that we have the deputy mayor rotation based on how long each councilor's lived in the municipality, with deference to our incumbent, Councillor Musson. So your function is to act in place of the mayor, same as when the CAO authorizes someone to be there to IC or take their place if they're out of the municipality for any length of time. And so we started with the residency. Reassignment date of each new deputy mayor is the following year's organizational meeting. So you're deputy mayor for a year. And the order goes as follows: October 28th, 2025 to October 27th is Councillor Musson. 27th of October 2026 to October 26th, 2027, Councillor Audrey Watson. October 26th to October 24th, from 27 to 28 is Councillor Carrie Levins. And October 24th, 2028 to October 23rd, 2029 is Councillor Kevin Reynolds. We're recommending through motion of council that Councillor Tracy Musson be assigned as a deputy mayor for her period of October 28th, 25 to October 27th, 26, the next day of the organizational meeting. And of course, within the banking schedule, we also do all the signatures and change of signatures and close things off. So that is council's recommendation.
Thank you. Anybody have any questions or comments on that? I just, not that I'm gonna blow my own horn here, but last year nobody got to act when I was here, because I made all 4 year meetings. So.
Thank goodness, thank you. I was just gonna make a motion that when I'm on, that he doesn't take time off either.
Thank you for that. All right, can I get a motion to accept the dates for deputy mayor as stated out here?
I'll motion to accept.
Thank you, all in favor? And that is carried. Awesome, moving right along. Okay, 7.1, meeting and budget schedule. So, we have some dates there, and Cindy, you want to talk about that, or
I can, listen.
if you don't mind?
Yep. So normally council is the second and fourth Tuesday of every month. So we've done that with the exception of Remembrance Day, because it falls on Tuesday. So we bumped that meeting to the 18th instead of the 11th. And then we added the 22nd and 23rd as regular scheduled budget meetings into the schedule. And I think, and then we took out COW in July and August, just to kind of give everybody a break for summer. And I think that is the only changes, correct?
Yeah, the only other big thing is that administration, this is something we need to discuss here. Administration wants to go to a 5 o'clock start time instead of 7. I don't know how everybody feels about that. It's,
I think I
it's,
can handle that.
we
I can
can,
make it.
I don't know. Talk freely, eh?
Currently, I can.
You can't?
I can.
You
Yeah.
can? Okay.
If a job, that may have to be discussed. Because I'm not currently at cooperators, but if I go back, I work till 5.
Audrey,
I'm fine
how about you, Joe?
with 5:30 work then.
We could do a 5:30 too.
We can do
I mean,
5.
We just started that there at 5:30. would be good.
5:30 works.
Okay.
Still have every second Tuesday, right?
5:30, Kevin, or
Second
5?
and fourth.
It says 5:30.
Okay.
I think that help you quite a bit there. Sarah Donna?
On the Tuesdays, we're still staying on the Tuesdays.
Yeah,
Second and fourth Tuesday, yeah.
would that help at 5:30
5:30,
for the
yeah.
15th to work for everybody?
Yeah, it's a really long day for
Right,
us.
Well, yeah.
just the regular time and then,
Yeah, your worship, and, your worship through the council. It gets us home before midnight, to be honest with you. And, yeah, a lot of times we're here till midnight, 11 o'clock for sure. Even after a council finishes at 9, 10, because we have bills to pay, you know, there's all sorts of things to do. But not only that, it keeps us more fresh, because I think all of us aren't at our best at 9 o'clock, 10 o'clock at night. And after 9:30, or 9 or 9:30, I think, the bylaw's not in front of me, we have to make a motion to move past 9:30 or 10. And you don't have time to discuss the issues that you need to discuss because you're tired. And most now, we did a canvassing, this is why we requested this. Most small towns in our area have moved to a 5:30 start date. And for example, Ruby's been doing it now for just about 2 years, and they absolutely love it. They're better thinkers, right? And we're all getting to the age where we're getting younger every minute. And that's kind of nice to be. And who knows, maybe after a little bit, maybe we have one every quarter where we bring in supper for council and we have a bit of a supper get together and then have a meeting. I mean, that's a decision for council, but on behalf of administration, we appreciate your consideration.
I mean, we could try it. If it doesn't work, we can always go back.
Question on etiquette then, we can bring a bag lunch, that's okay.
Yeah, absolutely. Yeah. I'm not spoiling lunch, but.
No, that's why I said bring
Put
a
a
bag.
coffee ball on.
Yeah.
That's fine.
All right, thank you. Any other discussion? No? A motion to accept the time change and the calendar for the rest of the year. Please.
I'll make a motion to accept.
Thank you, Andrea. All in favor? And that is carried.
22nd and the 23rd of November, what times does those usually start finish?
Oh, we start at 10.
And we'll let you know about them. Okay. And
Roughly 10 to 4.
Yeah, 10 to 3, 10 to 4.
okay. 8.1, meeting procedures bylaw 2023-10 review. Sarah Donna, you want to comment on that for us?
Thank you, Your Worship. So this is part of council's purview. It is your meeting procedure bylaw, and it governs you specifically. And we've identified the necessity for an update to the meeting procedures bylaw in a few key areas. And this happens every year. This is not normal to you. It's not normal to your council. It's not abnormal. So we need to do some administrative changes to the bylaw, such as renumbering and changing the layout in accordance with our current updated bylaw template. So that's an administrative matter. The removal of Part 5, councillor conduct, because Bill 50, introduced by the Alberta government, has removed the opportunity for municipalities to determine conduct using bylaws. So our code of conduct bylaw is, you're going to see it's coming to be repealed, because the province has indicated that they'll be writing the procedure of bylaws for all of the municipalities, and they have not sent us one yet.
Yeah.
So, but we're ordered to repeal it. So we're just asking everybody to be on their best behavior, because there's no sanctions anymore. So, be kind. The other thing is removing Part 7, notice of meetings as well. This section is covered by current advertising bylaw 2018-05, as well as the MGA's guidelines for advertising of special meetings. So there's certain parameters we have to do, and our advertising bylaw covers that, as well as MGA. No point in rewriting something that's already there. We need to remove part 8(1)(e) in accordance with the removal of council code of conduct. So even though we're removing the bylaw, we have little tentacles inside the bylaw that we have to remove to make sure that when it's repealed, it's done. We are recommending edit part 9(2)(e) to remove the mention of FCSS, Family Community Support Services specifically, as there is no longer a Family Community Support Services Board. So we don't have one in Thorsby, and the county of Leduc does not have one anymore either. We're looking at quarterly listening meetings, and it serves a better purpose. And other general alterations and clarifications on updated sections. So basically administrative changes, is there a period here, a comma missing here, that sort of thing. We'll be including the proposed changes in the request for decision the council will receive, along with the first draft of the proposed new bylaw when it is introduced. So we have it here with us, so you can see, I'm not going through the whole bylaw, but the bylaw is attached in here behind the request for decision. So you can take a look at the bullet points I just mentioned, and you can remove them inside the bylaw. We're recommending through motion of council that administration be directed to prepare the first draft of a proposed new meeting procedures bylaw, incorporating these changes for first reading at the November 25th, 2025 regular meeting. We cannot run all three motions in one meeting when you're passing a bylaw. You can run first, then council gets another chance to look at it, make the changes. If the changes are okay, you can run second. You may run third that same night. You run second and third the next council meeting, but you can't run all three unless it's some sort of emergent issue. So we'll look for passage of first reading at November 25th.
Thank you for that. So just homework for everybody then, just take that, and if you got anything, bring it back for the meeting on the 25th. So for tonight, I would just like a motion to direct administration to prepare the first draft for that meeting.
Thank you, Your Worship.
Somebody would like to make that motion?
I can make that motion.
Thank you, Tracy. All in favor? Carried. All right, and then 8.2, the council code of conduct bylaw 2022-14 repeal. So I'd say you talking. If you want to keep talking, you just said you were going to repeal that, but if you want to make a comment on that for me, please.
Formally, we are required to repeal it through Bill 50, and administration is asking council to repeal this bylaw.
Okay, so we will just do. Do you want to do first reading on this one?
No, we can repeal it tonight.
Okay, do all three of them then?
Oh, just something over here.
Pardon me?
One moment, sorry, Your Worship, point of order on me, not you. We have to do it the same way. First reading tonight, second and third November. Yeah, my apologies.
Down there for the 28th, but I just wanted to make sure.
So we want at 5 o'clock.
Can I get a motion to repeal Code of Conduct Bylaw 2022-14, first reading?
I'll do.
Thank you, Andre, all in favor? That is carried. All right. Council policy review 9.1, 123, travel and subsistence policy review. And once again, I don't think there's any changes, but Sir Don, if you want to just give us an overview.
Thank you, Your Worship. This comes up every year with the new council, and it comes up at every governance meeting throughout your term here. We usually like to look at the first one for sure, and basically this talks about the allowances that will be paid to council members and employees while traveling for business on behalf of the town. What are you going to get for mileage? What are you going to be paid per month as a councillor? What are you going to be paid for per meeting? And that's for conferences, seminars, other necessary travel, board and committee meetings. So there's going to be some travel into the Duke Foundation. The mayor will have travel with the appointment to the North Saskatchewan watershed, that sort of thing. So it's council's purview to take a look and to decide if they like the rates. It's good for discussion. We don't need to have 3 readings on a policy. Typically in this type of meeting, because it's an organizational meeting, you may want to have a look at it and bring your considerations back to the committee, the whole meeting in November. So basically where we're at now, page 42 of your council package, It's the team of administration adheres to this as well. You just don't get paid what you get paid today, but that's okay. So travel, it's CRA rates posted for mileage, but there's a caveat in this is that you have to supply a Google map as well. You can't just say I went 25 kilometers. Yeah, we have to know where you went, just the same as you want to know where we went. Lodging will be reimbursed at full cost, and discretion will be used in selecting a combination of reasonable rates and, of course, submission of those receipts. Now, sometimes if council or a council member goes to the federal municipalities convention, sometimes that happens, and it's in these cities where you'll never live on this. So then you would vote on, talk to our CFO, and we create a rate that you would vote on that would serve that purpose. Like in Toronto, you'd never work for $23 a meal. Ottawa's a nightmare. Even down in the Maritimes, you won't survive on this if you go to that particular conference. Exceeding the applicable meal allowance will be at the council members' employees' own expense, and of course, alcohol is at your own expense on a separate form that you would look after. You don't need to see it. Registration fees of the conference or event will be held in full, again, receipt. Travel expense claims are submitted once a month at month end for payment at the next account payable run beginning of the next month. So by resolution, you may alter any of the above conditions except in special circumstances. This format is now our new policy format. We've been working with it for about 7 or 8 months, and you're going to see that there's certain governance policies, there's certain financial, HR, etc. So we are presenting this for your review, and the administration would, I don't think there's going to be trouble between now and the November committee of the whole meeting, so we would look at your feedback on that matter. Unless you want to pass it tonight, that is your worship of council's purview.
Okay, I guess I make a comment on it there. And in the 4 years that I've been the mayor, we've never had anybody claim any meals. We've gone to a few conventions, but usually it's all included in there. And yeah, other than that, everything's the same. So if whatever council wishes to do, whether you want to look at it some more or you want to pass it tonight, it's up to you.
Is there an actual rate listed for travel?
It is.
Well, it's the CRA rate, so I send out a new expense form every year with the rate at the top. Like right now, it's 72 cents a kilometer. And those are actually in your orientation binder, the forms, but I will send them by email as soon as we have all your emails set up.
So if you want to review it, look at that stuff first and then bring it back to
I'm just thinking this agenda, I know 2 of the councilors, I'm not sure about Kevin, only just received information to read this as of last night.
Okay.
So I don't think anybody's had enough time to review.
Not in full.
Yeah. No,
So we could,
if that's the wish of
That's
everybody
next
here.
week. Or I guess then the question does, I didn't do a Google map yesterday because I didn't know about that.
We have
A chart.
a rate for the national,
Okay,
for
that's
everybody to Great Valley, to Edmonton, to South Side.
Right, and can I just say, if you go over the CRA posted rate, if you decide that that is a rate you like more than the CRA rate, it does become a taxable benefit.
Gotcha.
Yeah, but there's a charge for, I think, everywhere from Banff to Calgary.
Sure.
it's
Yeah, or you just Google Maps or something rate.
Yeah.
That's fine.
whatever Cindy and Donna charge, that's what we charge.
Yeah.
We don't charge them.
We don't charge you.
Our expenses are not charged, your worship, through the council, and the council Russian, we do not charge you any expenses for anything.
All right, thank you.
So you guys just want to look at that some more and bring it back?
I think that'd be great.
Okay, that's fine. Can I get a motion to accept this for information? Thanks, Kevin. All in favor? Carried. All right, then we have another one, GOV 0223, elected official remuneration policy, and I think that's pretty much the same thing. We haven't had a raise in 12 years, I don't think, have we?
Not since I've been here, you have not, your worship. So it's
Do you
fairly
want to comment on that?
Yeah, it's fairly self-explanatory to council, and you may want to have some time to look at this too, because council, whatever council decides, affects the constituency.
I think this one's pretty straightforward. Everybody sees this one. That's all right, unless anybody's looking for a raise. Kevin, you got a comment?
Don't single me out with a crowd.
Oh, you just look like you had a comment, that's all, I'm sorry. Anybody have any other comment? You want to pass this one? I think we can pass this one because it's pretty straightforward. And
So I'll make that motion, we keep it the same.
thank you very much. All in favor? And that is carried. Ten point one, signing authorities, appointment of signing authorities. Once again, Donna?
Thank you, Your Worship. So basically, what happens with the new council is some signing authorities are kept, as in Councillor Musson and His Worship Mayor Hostin, and then others are added. So all councillors are added to the signing authority, especially in their purview as deputy mayor. Administration pretty much stays the same because we haven't lost anybody from administration. So when we first got here, just as an aside, I think there was over, 20 CFOs, Cindy?
There was a lot.
A lot.
Of signing authorities that were no
Yeah.
longer here.
Yeah, they've been gone for years, but they still had signing authority with the municipality, which is very dangerous, and it's not good accounting practices, nor is it good internal control. So that's all taken care of, that's all cleaned up. So we're proposing no changes to the structure or the signing authorities. We're asking through a motion of council that the signing authorities be accepted as information, and it would be the office of the mayor, all officers of the council, the chief administrative officer, chief financial officer, and there is no office manager.
Okay, so we can just get a motion.
What did
Oh, sorry. I thought you were.
And I have the forms for Councillor Levens, Councillor Watson, and Councillor Reynolds on the printer to fill out for the bank, and then we will get the signature cards after I submit all the documents. So I'll give you those before you leave. If you can just fill them out and bring them back, that would be great. Thank you.
Thank you, Your Worship, glad to see you, thank you.
Yeah, go
I'd
ahead.
actually like to request not to have signing authority.
I think we did that in the past, that's up to you. Yeah.
Just for public record.
We would need a special motion for that, Your Worship.
Okay. Can I get a motion to, I guess, how would you want to read it, Donna?
Special motion to accept the request of Councillor Reynolds not to have signing authority on the business of the municipality.
Okay.
And would it be proper protocol to have Councillor Reynolds make his own motion?
It would not.
No, okay. All right, then I can make the motion.
Thank you.
Councillor Reynolds,
Yes, go ahead.
authority.
Mayor Hostin, through to, I guess, the rest of council and say another. What would the procedure be when it comes time in the last year of term? Normally the deputy mayor serves as a signing authority.
So it would be myself and Donna, that's what we did. We did that in the last 4 years as well, where Councillor Giles did, Gillis did. Gilbert, I get it right?
Councillor Miller as well.
Yeah, he didn't want to do it as well, so I don't see any problem with that. So we have a motion from Tracy, all in favor? Kevin, you're with that, good?
Yeah.
Thank you. I see. That is carried. Okay, a couple more here and then we'll get right here. Appointments, legal firm appointment, Reynolds versus Richard and Farmer, and that was Andrews from that company. So Donna, you want to just quickly, we just need to appoint them?
You do, Your Worship, I can explain a bit why we're asking them. They've been with this municipality for the last 4 or 5 years. And although sometimes we have to use another legal firm on certain circumstances, which are few and far between, Reynolds Mirth is extremely reasonable. There's a lot of times that I'll phone them on a matter, they can charge us $400 an hour, they charge us $150 for the call or nothing for the call. They're very, very reasonable. They're also municipal lawyers. You can get lots of legal firms that do legal work, but they are not municipal lawyers. And so Reynolds Mirth has been instrumental in helping us through the municipal corporation for water, different bylaws, different policies, different issues. When we first got here with paying out all the severance personnel that were unduly activated by past situations, not of our choosing when we got here. So we have two lawyers. We have Andrew, and of course we have Sean, and they're very good legal counsel. So we're very happy with them, and their advice has been sound and solid. So we're recommending counsel appoint them as our legal counsel.
Thank you. Any comments, discussion? No? If not, can I get a motion to appoint Ellsworth, Richards and Farmers? Thank you, all in favor? And that is carried. All right, 11.2, auditor appointment. Cindy, that's your little deal there. Would you like to comment on them?
Thank you, Mr. Mayor. So JAM Accounting Group is, I don't even know if they're like a division of St. Arno Vincent, because some of their emails still come St. Arno Vincent and our bill comes from JAM. So it's Jeanette, she's been our auditor for 5 years. Well, since we've been here in the year before that.
The year before, yeah.
So they've been our auditors for 5 years. We have a great relationship with them. Things are running smoothly. They're happy. I love them. I see no reason why we shouldn't continue. They come out in November. We do pre-testing. They come back in February, March.
Familiar saves you a lot of money as well.
It does. It does. Like they've
Somebody else in
been,
here, they're gonna have to do that much more work and.
Yeah.
so,
yeah, they're really great.
And we
They're
haven't had
accommodating.
any issues, so. Any comment? No? Motion to appoint JAM Account Group as our auditors. Thank you, Audrey, all in favor? And that is carried.
Oh, can you, sorry, Your Worship.
Yeah.
Can you say for the 2020,
I'm sorry, I certainly can.
please, thank you.
Motion to amend
Yeah.
the
Yeah,
resolution.
motion to amend to include that.
I do.
Thank you, Audrey, all in favor again? And very good. Perfect. Engineering firm appoints, Donna.
This is 11.3, Your Worship.
Yes.
It is our.
Oh, I'm sorry,
assessment.
11.3. I missed one. I got ahead of myself.
That's all right, Your Worship, no problem. So basically, we've had KCL Consulting for quite a long time. They're our assessor. They do all the assessments. They look after any of the challenges to assessments. We do not do any of that. They operate under the Assessors Act of Alberta, so they have specific formulas, specific methods of doing things that every municipality has an assessor. The bigger ones have internal assessors. We don't, we have KCL. And so the town of Thorsby's current assessors have worked with the town since 2010. And we are not asking for a change on this. Once your assessor is used to your town, and they are governed by this act, it's very strenuous. We're not recommending a change at this time.
Yep. And so just, I guess, since you said 2025, are we appointing them for just every year or 1 year, or is this a 4-year term?
Typically, we appoint it for a 4-year term, sir.
Okay. Any comment from anybody? Questions? No?
I'd actually like to suggest we go year to year.
It's hard for us to know. We're just got here, right?
Yeah, no, for sure.
So to assign for 4
Well, I
years, there's
mean,
no background.
I guess, I don't know, Cindy, you want to comment on that? I mean, they're familiar with the town, they're familiar with their tax roll, they're familiar with everything, right?
Yeah, they've been here
So
since.
in a year's time,
Yeah.
what's the difference if we renew them after a year?
Yeah, I don't know, Sue, Donna, I mean, you got, Jesse?
Mayor Halston, through the council, just as just to let you guys know, their agreement is in perpetuity.
Yeah.
So as long as it's not canceled, it actually continues year after year
Okay,
anyways.
so we don't have to say
So-
for 4 years, okay. Very good.
We can table this to rediscuss it next year.
Okay.
No,
It can.
No,
be
it reoccurs.
Oh,
It
right.
reoccurs. So it is, technically it's year to year.
Yeah.
Just on a reoccurring.
Unless we have.
So we don't
a reason
have to
bring it
assign
up.
a 4-year
Fair enough.
and then
That's
come
right.
back in.
unless there's reason to
Right.
work with them and break the agreement.
Fair.
And if I'll do, just as information, if we had to break the agreement, there'd be some issues with the provincial government, not in a bad way, but they'd be going, what's going on here? What are you guys doing? And what is KCL? doing?
Fair.
So, yeah, good question. So very good.
Were they here prior to you guys?
For
Yes.
2010, this is 2010.
2010.
And prior to that?
Yeah.
Well, 2010 is when they started
2010.
with us.
Yeah.
That's
So-
15.
They've been here for 15 years.
3 councils back, basically.
Yeah,
That's correct. Okay, so you just want a motion to accept it, Don, or do we have that?
Motion to accept, sir.
Okay, then a motion to accept this for information? Thank you, Audrey. All in favor? That is carried. Now we'll get to 11.4, select engineering. Domino, once again, please.
Thank you. We regularly reaffirm the current appointments of many different firms and agency that we work with, and the engineering firm the town uses is one of these appointments in select engineering. There's specific civil engineers you want engineers in your municipality that are civilly trained and civil understanding to your underground works and so forth. This last year, select engineering produced the road, I guess, we call it the road horror show, where they specifically outlined certain roads that have to be done. And so that's what we place in our capital budget that we'll be listening to during the budget process. Can we always fix what they suggest? No. Or we just keep moving them forward, or we fix what we can. I will indicate here that it's funny, when Andrew was talking about grant money, when we first got here, Alberta Transportation gives you all the grants for water, wastewater, and so forth. It's just the way it is, the way the provincial government set up. We had $127,000 or $9,000 grant to fix a big main, and the administration of the town at the time, and this is just factual, it's not blaming, because I don't do that, but factual at the time, they used it for something else, i.e. paving. And so when we got here, we got asked to write a report on this grant that we had used for the big horseshoe main, and it's a big, big main. And I couldn't, because we didn't use it for something. So I had to write to the minister, and I had to do a bunch of paperwork, talk to the assistant deputy minister and so forth, to be able to keep our money, even though we didn't use it for what it was purpose intended. So when we get grants in the town from the government, especially for transport, infrastructure and so forth, underground works, when we say we're gonna fix something, we have to fix it. I was fortunate, I knew some folks inside transportation from consulting there, and I didn't pull any strings. I just said, we haven't been here, please. This town can't afford to pay back $129,000. It went to the minister, which is Minister McIver at the time, and he granted us through a formal letter to keep the money, and we agreed to sign relief. The problem is, the horseshoe main still isn't fixed.
Right.
The road that was paved was the road by the fire hall, and of course, we all know how lovely that is. So, Select Engineering had designed that horseshoe main. They were not paid either at the time because they switched, and so we had to look at that. Select Engineering is very good. We're used to working with them. They know the municipality. They look after Warburg. They look after Calmar in certain circumstances. And there's really only, in our opinion, 3 good ones. I've worked with 2, Select in Edmonton, Tagish, and Red Deer, and now MPE out of Lethbridge. I mean, MPE is too far away, but you want municipal engineers because they can guide us properly. So what happens at budget time a lot of times is we'll have the engineer come in and provide information to council about what they see as emergent, non-emergent, and very difficult roads to fix. So we've got a lot of different things going on with Select, and we would like to appoint them for another year.
Mr. Mayor, can I ask then, is this the same situation that it just goes year to year unless
That's correct.
it otherwise changes?
As far as I know, yes.
Yep.
Oh, motion to approve. To keep Select.
Okay, all in favor? Yep. And the last of the appointments there, 11.5, planning and development, senior planning and engagement.
Thank you, Your Worship. This is Liz. Some of you come into contact with Liz, and you've seen her on the screen and so forth. Liz is one of the few registered planners in the province. There's a few, but she's registered masters in planning. The town of Thorsby never had a planner before we got here, and of course, Liz, like all of us, made sure we fixed some things up as well. A lot of planning issues had to be fixed. We had to have a new land use bylaw coming up in 2026. Is going to be your municipal development plan and your municipal development plan. And these aren't huge documents, but they are legislated because if we ever have a challenge to a development permit, the challenge goes through the Regional Subdivision and Appeal Board, and they only make decisions based on the land use bylaw, municipal development plan, and intermunicipal development plan, because they're legislative documents. That's the only three documents they can use. Liz has been instrumental in solving a lot of issues this year. Some we couldn't solve just yet, but she also understands subdivision. She understands all the nuances with them. She understands what has to be done, etc. So she's very knowledgeable in that. She's also very knowledgeable in setbacks, helping people with variances and those kinds of things. And we find that a lot of the lands in Thorsby, the lots, I will say, there's challenges to everything, because when you don't have a planner, just stuff happens. And you need someone experienced to say to the lot owner, okay, we can do this or this or this. So we're recommending through motion of council is the plan to be accepted as information.
Phil? Any discussion, questions? No?
I will make that motion.
Thank you. All in favor? That is carried. All right, and we're gonna get into the boards, and I think maybe we can make a motion for all of the standing committees all together. That's okay?
Your worship, yes, for sure. Thank you.
So just a little bit of history on this here. This is, I guess, these are for 1 year. I went through these here, and it can be, if you find out you're on a board or standing committee and you don't like it, we can change it. And next year at this time, we go through them again. So these are not written in stone, but I try to make it as fair as I can for everybody here. So if you want to go through them there for me, Donna, that'd be.
Yes, thank you, your worship. So standing committees, committee of the whole, will be your next council meeting. Everybody's involved in that. And again, it can be called priorities and methods meeting as well. Emergency management committee is mayor, councillor, and CAO. So that would be Mayor Hostin, Councillor Watson, because you have level 1 and 2, and I have 1 through 4. So that's what that is. The Regional Assessment Review Board is Mayor Hostin. And the Subdivision and Development Appeal Board is mayor and or myself. We're both trained, but I cannot, and neither can the mayor, adjudicate on matters respecting Thorsby. We can't. So where we called last year, no. We'll probably have to take the training again this year, and I have to be able to beat the mayor because he beat me by 1 point last year.
I believe you're trying to vote that, Jesse, for us.
I'm getting you your ARP training.
Okay,
That's first.
all right.
The boards, the Duke Regional Housing Foundation, Councillor and alternate, and Councillor Musson. Councillor Reynolds is alternate, and that's a big board, and it does well into the community. It does a lot of good for Leduc in our areas as well. Thorsby Municipal Library, 1 councillor, and that'd be Councillor Carey, and you aren't a board member, Councillor Carey. You are a trustee.
Similar to what Tracy was.
Exactly, and the last 3 years, we had 2, an alternate and of course a board member, but we kind of got, well, the CEO got our fingers slapped a little bit by the province because you're trustees and we can't have an alternate, you're either there or you're not.
Gotcha.
So, which is good because the trustee actually, it's a better appointment for you than the board, so that we fixed all that.
But Carrie would be allowed to vote.
Yes,
Yes.
100%.
Oh, that would be the difference.
Yeah, and then when they appoint board members for the library board, we have a certain way we have to report it to the provincial government under the Library Act. So the first 2 years we did it wrong, but we since straightened that up because the province got a hold of us and told us. So sometimes they don't send their bulletins out so we can catch them, but anyways, that's all fixed too. There's a certain way that we have to report it, and of course, that's what we do. So then the Yellowhead Regional Library Board is Councillor Reynolds with Councillor Musset as an alternate. And just for the sake of conversation, the waters are misprint. Take that out.
Okay. Any discussion, questions? And I think John, you'll have information, you'll get dates for when these meetings are, or get started going right away.
Yes, your worship, what happens is once you've been on the first meeting, I'll let you know when the first meetings are. Once you've been on that first meeting, then you have your own agendas and dates to adhere to it.
Okay, any questions, discussion? No, motion to accept the standing committees and boards as is. Thank you, all in favor? That is carried. And adjourned, and that's done for the first meeting.
Well done, your worship.
Well, it was quite long there for sure. So the second meeting, do you want to take 5 minutes or not? Or do you want to get right up? Okay, let's take 5 minutes. Ed, we'll get you in there right away. Thank you.